Woo! Good morning. I've been feeling like I'm playing a game of Frogger. You know, when you get like a little bit across the street and then you have to back up, and then you get across the street and you have to back up again, and then you get splatted. I couldn't figure out what time this was. I couldn't figure it out. And I want to know, is old Teardrop gonna be there? Is old Teardrop gonna be there? Well, let's start our morning the way we do on Wednesdays. We know what today is. It is Mean Girls Day. We know we wear pink. We know we're proud of it. And we talk to each other because, well, we're friends.
Oh, guess what day it is? Guess what day it is? Huh? Anybody? Julie, hey, guess what day it is? Oh, come on, I know you can hear me. Mike. What day is it, Mike? Leslie, guess what today is?
It's hump day.
Woo-hoo!
It's hump day. We're almost there. Gonna let everyone know there will not be a show on Friday. We have to go to the doctor Friday morning, and then we have to go over to Ghetto Skokie, also known as Muskogee, Oklahoma, for a wedding. So I'm going to try to do 2 shows today, but I do not know how long this hearing's going to last. If not, there'll be 2 shows tomorrow. Who's got pink on? Raise your hand.
Oh, good. Well, here we are again.
Yeah, but this time we're seniors.
And we're gonna rule the school.
Jan, that is so adolescent. We are adolescents.
We don't have to flaunt it. Okay, girls. Let's go get them.
Woo! Woo! Just me said my soul is pink. That's what I'm talking about. You better believe it. You better believe it. Wow. Let's see. Jules is getting horny. She said pink drawers count. Hope so. Ooh. Ooh, look at Jules. Telling us all about her lingerie. Good morning, Ashley. Good morning, Ashley. Anita said, I was talking about that commercial to our son. I showed it to him, and he laughed so hard. The Queens of Rydell High. One of the best movies and musicals ever. Let's take a second and tell everybody good morning, and then we are going to get to it. All right, and thank you very much to Sophia Petrillo. She gifted 5 Crime Lines and Lies memberships. Who is sending me messages on Facebook? Oh, I don't know. That's how it goes. That's how it goes. The balls of a burglar. Think about it. His constitutional rights were violated. Now, listen, these appellate attorneys, they know how to throw and wait to see what sticks. And 9 times out of 10, it normally doesn't. What's really messed up is when it should stick is when someone has been put in jail that is innocent of the crime. This dude, either way, has got, 50, 60 years just for his gun crimes. So why are you wasting anyone's time, particularly the New Hampshire Supreme Court, over 3 constitutional violations? Let's go through Harmony's violations, okay? On the way to Burger King, or as Prayer Garden calls it, Booger King, to get their sandwich and their little tater tot rounds and then had to go back around to get extra ketchup because Kayla likes the ketchup, man. She's got to have the ketchup with her tater rounds. On the way, closed fist, hit Harmony so many times that he said, I think I did something this time. I think I did something this time. They heard a whimper. They put her in an Under Armour bag after they finished their breakfast and went to get drugs and went about their life. Isn't that great? Well, there's Annette. I'll tell you what, Annette, you have a big fan club here. That was a great show yesterday. Chrissy said he punched her in the face so hard she's not here anymore. True Crime Beat said, member for 35 months. Harmony deserves so much better. We love Harmony. Oh, and look at that. Sister Karen said, happy to be a part of the CLL family. You better believe it. I'm going to get better about catching those. I am. Because sometimes on my end, on StreamYard, they show up as like a regular comment. They don't show up in green. So what I have to do is I got to go to the starred department. Pilo's mom, thank you so much for the super sticker. That is amazing. All right, let's get to it. Looks like they're filing into court, but first we're going to look at this.
Like man to man, can you tell me that she's alive?
Is you gonna play the same word games that you played with me the other day?
It's not word games. Why is it you have so much trouble talking about Harmony?
Because I got nothing else to say.
So where is Adam Montgomery? The man convicted of murdering his daughter, Harmony, is back in our spotlight this morning because his whereabouts are apparently a mystery. A judge dismissed a wrongful death lawsuit filed against Adam Montgomery by Harmony's mother, Chris.
Piss on that fat whore. And if you look at the members tab, you can see her new boyfriend. What a winner. What a winner. This judge does not want to hear Crystal Sorry, Mini Meth, does not want to hear her lawsuit. You know why? You know why? Because it's a waste of time. Teardrop is a convicted criminal. He has a job in jail. I think he makes like $1.13 an hour. And that's so he can get his socks, he can get his Crocs, he can get his beefaroni, he can get his Pepsi. He has some money for ice cream day. You know, he can do things like that. You know, every now and then he'll have enough put back to get him some cigarettes. There's no water to suck out of that rock, okay? And I really hope after what happened to him in New Hampshire, I hope if he shows up today, I don't know if they're going to bust his ass from Virginia or not. It seems that some people are confused about where he is now. So I'm wondering if he didn't have a little problemo in Virginia. But if they haul his ass in there, I would put a toilet plunger in his seat and say, you can sit on that to make you more comfortable. If you know, you know.
Crystal Sorry. Now, this was allegedly because authorities can't find him to serve him. However, Crystal Sorry's attorney says they did serve him. He said, quote, Adam Montgomery was timely served with the lawsuit, and an affidavit of service was filed with the Superior Court on September 15th, 2025.
She's such an idiot. They're probably serving the wrong state.
Therefore, we believe this is a court error, and we'll be looking into it first thing on Tuesday. That's today. All right, now we know convicted killer, I call him Coward Montgomery. Coward Montgomery was transferred out of New Hampshire immediately after his sentencing took place, and he was allegedly moved to Virginia. But a search of prisons, and we've done it at Court TV in Virginia, it turns up empty for us. So we're wondering, where is he and why is his location being kept secret. Let's talk about that. In the studio with me, I have criminal defense attorney and civil rights attorney Mark Bagno. And joining us remotely for the first time, retired assistant sheriff in Charleston County, South Carolina, Mitch Lucas, who also ran the largest jail in South Carolina. So Mitch, welcome to the show. I'll start with you here, please. What do you think in terms of his whereabouts being kept secret? I'd love for you to weigh in on this, if there's any reason that may be actually occurring.
Do they not know how to read? WMUR out of New Hampshire said that he was violated at the prison in New Hampshire, the men's penitentiary, the pen. And they took him to Virginia. Why are we playing Where's Waldo with Teardrop?
Well, the only thing I can think of is if he was recently taken to the Virginia Department of Correction, they had.
Thank you, dude. That's what I'm trying to tell him.
Him in some receiving evaluation center, and it's not showing up on their website. I don't know of any other reason why he would not. It would not be clear where he's at.
And with serving an inmate with process, Mitch, how simple or how complicated is that? Explain it for our viewers, please.
It's a little complicated. The jail would have to produce the inmate because obviously the process server couldn't simply walk into the jail and find the inmate. So it's a little cumbersome, but it's not. It happens on a regular basis because inmates have to participate in their own defense and in any type of court proceedings. So it's not that hard.
Sure, appreciate it. Mark Bagno, legally, this is a head scratcher, isn't it? Would love for you to weigh in on why you think this got kicked if this attorney if he's correct that Adam was served.
Well, if he's correct, then it is a clerical error, because I see that in his statement, he says that Adam was served and the return of service was filed. So if everything was done right, if he was served, if the return of service was filed, then something clerical happened. Either maybe he filed it under the wrong case number and it went into the wrong file. I mean, I'm speculating here. Maybe the judge's office was looking at the wrong file when they issued their order. But if it really was served and if it really was filed, then they should be clear.
Sure. No, appreciate that. In backing up a step, Crystal Sorey got a big judgment, a $2.5 million judgment from the state of New Hampshire already. Why in the world is she suing that animal who's gotten?
That's what I'm talking about. $2.5 million. $2.5 million. Now, mind you, her attorney took some of it. Some of it went to Jameson, some to another child she has. And now she wants to do a wrongful death suit with Adam. I think because their next step is to sue the state of Massachusetts. Crystal was the first one to fail Harmony. And the discovery process, I guarantee, was not easy for her. Was not easy for her at all, because she went from $50 million is what she was suing for. And they got it down to 2.5, which happens to be their policy limits for insurance. She started out that she wanted them to publicly admit that they failed Harmony, and they said, no, we are not going to do that. You take your 2.5 mil and get on down the road and buy yourself a turkey sandwich. That's it.
Nothing to take. What do you think about that?
I mean, it's a head scratcher, right? Why do you sue? Why are you going to put that much resource and energy into suing somebody that you can't really get a recovery out of? What struck me, though, was the timing of it, because it's my understanding that lawsuit was filed about a month after that $2.5 million judgment. And so I don't know if behind the scenes there might be some fight over that money. I mean, I don't know what's going on behind the scenes. I know that in most states, a person can't collect in a wrongful death lawsuit if they're the one that causes the death. So if you kill your husband, you kill your wife, you kill your child, you can't then sue somebody else for wrongful death and collect. But I don't know the law here, and I don't know if maybe there is some fighting behind the scenes that is driving this lawsuit.
That's great insight, Mark. Yeah, you wonder what's going on. Something I feel like.
Well, a little birdie told me that Crystal's having a very hard time getting a hold of that money. After the attorneys paid themselves and recovered their expenses, and a trust fund was made for Jameson, Adam's other children, who Kayla's mother is raising, so 3 children. She's waiting for her paycheck, and by the time they get done, it might be $30,000. Well, that's not going to get her and her new boyfriend to Paris. And they put in the paperwork, she, on her own, is responsible for the taxes. And it's a capital gains tax, which is going to eat a lot of it up. Okay? A lot of it up. Like when, never has happened to me, like when you win the lottery. Okay?
There's something maybe we're just not sure of. There's some motivation here because what utility would there be? I have a clip. This is from trial because we know Adam Montgomery also is going to be in court this week. He's trying to appeal his case. And so let's talk about some of the issues that came up. The beating of his wife, Kayla, came up. She testified to that. Let's take a listen.
He wanted me to tell him who I was cheating on him with, or if I was working with the cops. And
these people, always cops involved, always slinging their ass somewhere else. All are felons that have guns and they know they're not supposed to have guns. Then, of course, they have to get their fix. A job doesn't compute in their head. And Kayla, since she loves Adam so much, put her in the cell with him. And what's really sickening is she should be on some kind of list, but she's got a new boyfriend who has minor children and lives near a school zone.
I kept saying that I didn't, and he kept hitting me anyway. He would accuse me of sleeping with the guy downstairs, sleeping with all these different people, that I came out of the window one night. I couldn't take care of the kids.
Okay, and so this goes to some of his complaints coming up on appeal, and we're summarizing here. There's more issues laid out in the briefs that were filed, but so he...
Okay, I'm going to play Google Attorney real quick. Anybody want to help me play Google Attorney? I'll drop the link. Help me play Google Attorney. We can all be Google Attorney and judge. It was the court's failure to sever the difference between the assault and the murder charges. I'm not the sharpest knife in the drawer, but I understood it. Evidence of past abuse that was admitted. Well, they explain that as character. Montgomery's interaction with the police in 2021 that was shown to the jury. All right, backstage, we have who I call our expert on the case. And that is your friend and mine, Susan. Susan, what do you think about this rigmarole?
Well, I think she is just trying to get clout because she's going to bring the other lawsuit, and people might have forgotten about Harmony and her, but she's not going to mention her dirty deeds in the part.
No.
I can't stand these people. I can't.
And if anybody needs a reminder about what a POS crystal is, we have a whole playlist. Now,
Yeah.
do you think they're going to bustle Adam up there and make him appear in court for this appeal?
I think if it benefits Adam, Adam's more than willing to go there until it comes down to the questioning part and he's out of there.
Mhm.
He's got to make a good impression. He wants this appeal. That's just my opinion.
I would think that they're doing it backwards because you would think the first appeal would be for the gun charges. I think they're not screwing with that because that's federal. That's when the U.S. Marshals were after him.
Has he put in that appeal yet?
Nope, they have not done anything with that. This is all about Harmony. Now, if they were appealing the gun charges, I might kind of understand that considering all the scumbags that are around him. I could kind of see that one getting lightened. I really could. Not that I wanted to. Not that I
Yeah,
care.
he could pin that on just about anybody he was with.
Yeah. I could see that one getting to the appellate court. But Harmony, it's just another slap in the face to that beautiful little girl.
Not if he's going to pin it on Kayla.
Well, he tried. All he had to do was take the stand.
Well, I'm saying he probably will say that this time so he can get his new trial.
Well, I mean, go ahead, get you a new trial. Get Top Mom when Crystal won. Do what?
It's not going to do him any good. This internet stinks. I'm sorry.
No, I get it. So this is the basis for his appeal. Court's failure to sever the differences between assault and murder charges. As in, they shouldn't have let Kayla testify about him beating her ass all the time. Evidence of past abuse that was admitted. Well, the past abuse towards Harmony is definitely part of the case. And then his interaction with the police when he was outside the Walmart there and he was sleeping in the car in the Coors Banquet shirt.
Yeah.
They're saying that should have been shown to the jury.
And that's pretty much what I thought too.
Mm-hmm.
It's prejudicial. Who the hell cares, honestly? The only rights that were violated were Harmony's, and I can't stand this. Can't stand him. I said something bad.
All right, we have a question from the chat. Why does he want a new trial? The coward didn't show up to the first one. It's funny, he was all hot and bothered over the guns, and he sat there for every day of the gun trial, but didn't do shit for Harmony.
In my opinion, because the last stuff had bad stuff that made him look bad. If he can get that thrown out, he can bullshit his way through this trial, he thinks. Not happening, friend.
No.
Yeah. He's nasty. I can't stand it. And I hope they cut off his teardrop.
Shave it off. Shave it off. That's what I say. Shave it off.
Balding.
Is upset that the court didn't sever the assault charges he had from the murder charges. But remember, Harmony was beaten to death, was the allegation, so let's not forget that. The past abuse information was admitted. Kayla testified to what you just heard. His interaction with police on body camera footage shown to the jury as well. He's upset about these things. Mark Begnaud, is there anything that you think has legs here?
It's hard to say. I do know. So the gist of most of the argument seems to be that there is other evidence that was brought in that wasn't germane to the night in question, the day in question. And so, for example, the severance issue has to do with a July assault incident, which was months before the actual death. And so that's what they're going for. And you do see reversals on that ground sometimes, where you've got evidence that's too far away from the crime itself that's coming in that's unduly influencing the jury. So reversals happen in this universe, though honestly, the behavior here is so similar and it all is sort of a long course of conduct that I don't love his chances on appeal.
Oh, I love that analysis, Mark Begnaud. Mitch Lucas, I want to go back to you here, please. This guy, Adam Montgomery, bad guy, and I started calling him Coward Montgomery when he wasn't showing.
She should hang with us.
Bingo. Coward.
With us.
The guy that said he doesn't love his chances. Oh, I do. I love his chances, which are 0. I love it for him. Kick my ass. Oh, I can't stand it.
That one. I had to clap on that one. I love his chances because his chances are nothing.
Nasty.
His chances are nothing.
Up for his trial. He wasn't showing up, and his attorneys did a fine job proceeding without him. So many of us are wondering, are we going to see him in court for this appeal? Would you speak to what it's like when you have an inmate like that who doesn't want to do what they're supposed to do? It comes time for their trial. They should be showing up for their trial, but if they don't, they don't. What's that like when they fight you on that in the jail and you go to transport them and they may make it difficult on the deputies?
It makes it a high-risk transport, high-risk housing, and you have to take particular caution with them because if they're being that disruptive with regard to court proceedings, they're that disruptive with jail operations as well.
Yeah, I bet. Does he seem like a dangerous guy to you, Mitch? And I guess part 2 of that question, I also wonder if he's got a target on his back because he's a child killer.
No, he's got a target on his butt. Okay.
And his front.
That's where the target is.
Nicer guy. I'm glad he does.
Nobody cares about his back. But those big old black guys, they all turned shit in his toilet. They grabbed him, they put his face in it, and then they gave him the plunger treatment. And I don't mean with the suction part.
Ask me if I care.
You know you went straight to church to pray for Adam's bunghole.
I pray for myself because I hate this man. And it's a sin to hate as much as I hate this man. I am not okay with him.
Well, I mean, like I said, if I was the judge, I would have a plunger sitting right there. Because, I mean, he was in the infirmary for a long time. They had to put a maxi pad on him because he had all that, blood, thing going on. And Sandy mom said, I hope they took that stick on the toilet plunger and rang him like a bell. Oh, he screamed, he screamed like a bitch.
That was funny. Oh my goodness.
He screamed.
That was funny. Give her an A+ for that comment.
He had a mouth full of shit. He was screaming like a stuck hog. And they had to take him to the infirmary. And then he had to start wearing Kotexes for a few days. And then, since he has a mark on his back, in air quotes, they took him to Virginia. But I guess Crystal doesn't keep up on her own daughter's case. Because if I know where he's at, and Susan knows where he's at, and Pilo knows where he's at, and V. Oakley knows where he's at, then how did Crystal not know?
I honestly, I don't think that she really cared She just wanted to get it out because she's not going to get nothing. She knows that. And it's going to cost her money to go to court. Maybe she just wanted it filed and she would get the press, the clout. It would make her look good.
Yeah.
And I hope they tattoo titties on her back.
Well, I can tell you right now, it's a wonder he's even survived. Did you hear about that one guy? Chrissy and I were talking about this morning. What's his name? Ian Watkins. And he had abused all those kids. Well, he got killed in jail. And his ex-girlfriend said, I can't believe he made it that long.
That's what it is.
Mm-hmm.
I don't feel bad for him. That's for the victims.
Well, that's why I was having issues with some of those people that were leaving me those horrible comments about Jack and Lily or, Summer Wells and everything. And they're like, innocent till proven guilty, Brooks. I can't believe you're saying these things about Daniel. I'm like, oh, piss on that.
I don't need somebody to piss down my leg and tell me it's raining. I can see.
Mm-hmm.
You know what's going on.
That's what I'm talking about, girlfriend.
Nah.
Mm-hmm.
These people are crazy.
Mm-hmm. They just always
go. X out and go to somewhere where somebody has the same opinion as you. If that's what you want, then that's what you want. I'm sorry.
No, they are suspect sympathizers, and I don't have time for them.
Exactly. What about the children?
Mm-hmm.
Now, that's who I worry about.
Would you weigh in on those things, please?
Both. What I've read about the case, he would be a maximum security type of inmate, and one that you would have to protect the staff from and protect him from other inmates. It's not unusual for people who kill children to have a bad time of it in prison.
Send him to Susan's house. She's got a special.
Yeah, I got something for him.
Yeah,
come on.
She's got a special soup recipe. It calls for 3 parts freeze and 2 parts water and some beans. He'll love it.
My son can operate a backhoe. Come on.
Yeah, go to Susan's. Go to Susan's. All right. So this is one of the big things that they're having an issue with. This is the body cam footage of when they found him living in his car at the Walmart.
You ladies, watch out now. I'm worried about you. You're going to be running for him and writing him letters.
I could see V. Oakley crawling in that car with him. Mm-hmm. Insanity Mom has a really good idea. Hold on. She wants to know if there's a way to throw Adam throw a pizza party for the inmates that got him. We can work on that. We've done it before for, police departments and stuff.
Yeah. They can sit with us.
Mm-hmm.
Prosecutors now believe that he murdered her. Well, tonight, our first look at body camera video showing the moment police first questioned Adam Montgomery about the disappearance of his daughter, Harmony. Prosecutors now believe that he murdered her.
WBZ obtained some of the evidence that prosecutors have used to build their case, and it shows Harmony's stepmother was the first to tell detectives what happened to the little girl. WBZ's Beth Germano has the evidence and some new information on the case against the stepmother.
Hey, keep your hands where I can see them. What's going on?
He was found sleeping in a car in a Manchester, New Hampshire parking lot on December 31st, 2020.
And there's Kelsey that can't be bothered. She's still sleeping in the car.
Yeah, Kelsey's dead now.
Kelsey's dead, and I agree 100% with Diana Bond. She said, I don't believe his girlfriend died at her own hand. No. Those two people on the outside. We have seen that cast of derelicts. Stand after stand after stand after stand.
Investigators caught up with Adam Montgomery for the first time to question him about the whereabouts of his daughter Harmony, who hadn't been seen in 2 years and is now presumed dead.
It just seems a little strange that you don't want to tell us where she is.
All right, I got nothing else to say to you guys.
He repeatedly refused to answer questions in a 45-minute interaction, but did claim she was alive.
Your daughter's alive? Yeah.
You're sure?
I'm positive.
You're like, swear on your life.
I swear on my life.
But the body cam footage later reveals he said Harmony had been picked up by her mother around Thanksgiving in 2019, and he hadn't seen her since. And during a police interrogation following his arrest, again he refused to cooperate.
Can you make me a promise? Like, man to man? Can you tell me that she's alive?
You're gonna play the same word games that you played with me the other day.
This week, Adam Montgomery was charged with second-degree murder in the death of the little girl, whose body has never been found.
In the meantime, a plea deal may come next week in 3 charges against Harmony's stepmother, Kayla.
Well, and she got that. Okay, they're filing into court.
Okay.
And Attorney Phelan, I understand you reserved 2 minutes for rebuttal. Please proceed.
You may need to turn your volumes up.
Today I'd like to talk about 3 issues. First, the court erred in joining the July 2019 assault charge with the homicide-related charges. Second, the court erred in admitting as intrinsic evidence of other assaults in the weeks prior to the homicide and of blocking communication between HM and her mother. And lastly, these errors were not harmless beyond reasonable doubt. I did raise another issue in my brief, and I'm happy to answer any questions about those, but I'm going to focus on these. The principal concern with these issues is that a defendant be tried on the merits of the charged act and not on propensity and character inferences that may be drawn from evidence of other acts and wrongs. On the first issue, the cases simply should not have been joined for trial. They were not logically and factually connected in a manner that does not solely rely or demonstrate the accused has a propensity to engage in criminal conduct.
Does it make a difference? Go ahead. Does it make a difference that the defendant had joined and the state's assented to motion for joinder in the first instance?
No, I don't. And the reason I don't is because my recollection is that the parties agreed to joinder early on in the pendency of the cases. And then as they neared trial, the defense moved to sever them for trial. The state did not contest that the defendant had a right to do that and to have the court look again
So if
at
it,
whether it should be
I guess
severed.
my question is, if it was in the best interest of justice at the moment, the defendant agreed to join the cases, what changed?
What changed is I think through the as defense counsel said, through the development of the case in preparation for trial and additional information that was coming out about how the state was intending to present its case. And defense specifically referenced new discovery or new information in Zwicker letters that were being produced to the defense.
Are the Zwicker letters part of the record? Because I looked at the motion to sever, it references the Zwicker letters, but I didn't see them in the appendix.
No, they are not. But defense counsel talked about what was in them and state's counsel when they argued the issue about whether the charges should be severed for trial. And at that point, the defense was primarily concerned not only from what was coming from the Zwicker letter, but in how the defense was perceiving the state's theory of the case going into trial, that this was going to be a trial about demonstrating a pattern of abuse. And that was going to be the prejudice that was going to result to Mr. Montgomery by having the charges continue to be joined for trial. And that was the principal concern that the defense had and articulated to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe one of the Zwicker letters did include information from her. I can't remember exactly which witnesses were involved in those.
What's the significance of the 2 different states of mind between the July assault and the murder, the reckless murder?
I'm not sure what.
In terms of this analysis, does the state of mind of the two different criminal acts have any bearing on our analysis for joinder?
I don't think so. I haven't thought about it in that way. I've thought about it in going through the Brown factor analysis that this court has articulated, as well as the tests that the court uses to determine interests of justice. I think the concern when you join those two cases together in this case is that you have evidence of the July assault, which, as you note, did have a different mental state, a knowing mental state. But that evidence rested on several different witnesses who did not have credibility problems, whereas the homicide case rested on the testimony of Kayla Montgomery, and she had significant credibility problems. So to the extent that evidence came in through the joinder of these two cases for trial about and through witnesses, third-party witnesses without credibility problems, the July assault was much stronger. And to the extent that the jury likely had significant doubts about what Kayla's version of events were for December 7, which is when the homicide is alleged to have happened, the jury could very likely have relied on the strength of that assault charge case in resolving doubts against Mr. Montgomery on the homicide charge.
Counsel?
Yes.
So is it fair to say that the Zwicker letter changed the defense's calculus with respect to the best interest of justice prong of the analysis, but that when there was a stipulation to join the two cases, that the defense had concluded that they were sufficiently related, that they ought to be joined? In other words, you're challenging relatedness, and my question is, doesn't the Zwicker letter only go to the issue of best interest of justice?
I don't think so. My recollection of the hearing on the motion to join or the motion to sever, which was also the final pretrial conference, I don't know how in-depth, I can't remember how in-depth counsel for the state and the defense went in to the original calculation or the original analysis of joinder. There wasn't a prior hearing on joinder. And so I don't know if we can be very clear or have a clear understanding that the defense at some point thought there was a relatedness. Or the defense might have thought, just like the state, there may be some efficiencies in trying them together. But as the cases got towards the trial date, it was clear to the defenses, they made clear to the trial court that they were concerned about the effect of a potential pattern of abuse being used primarily to affect the jury's weighing of evidence on the homicide charges.
At the time that the state initially agreed to joinder, was there a decision made or on the motion to eliminate to prohibit the intrinsic evidence that came in?
I don't know if, I think over a year earlier is when the cases had gotten joined and started towards trial. I don't know at that point whether there was any written agreement or stipulation about evidence or whether it was tied to the admissibility of other evidence in the case. And the other issue that I want to address this morning has to do with that ruling about some of the evidence that the court determined was intrinsic. I don't think that was there was any agreement that tied the intrinsic evidence issue to the joinder issue.
So the admission of but you would agree, I assume, that the admission of this intrinsic evidence, the assaults and abuse and neglect that occurred in the weeks before the murder, that affected the admission of this assault in July, that it made it compounded.
Correct. Yes. I mean, I think both issues are intertwined in the prejudice that resulted to Mr. Montgomery. And it's, even if we're looking at the joinder issue, I think to your point, the prejudice is not just to his trial on the homicide charge, it's also potentially to the trial on the assault charge, because as you point out, the intrinsic evidence came in as intrinsic to the homicide charges. And certainly it was there in the case for the jury to use in assessing both charges, the assault charge and the homicide charge.
So I want to give you an opportunity to address harmless error, but why don't you proceed with your second argument?
Yes. So with respect to the intrinsic evidence issue, there were two pieces of evidence that I focused on in my brief, and I believe it was error. They were not intrinsic to the homicide-related charges, which is what the trial court found. It was the assaults in the weeks leading up to the homicide, and then the bar of communication. With respect to the assaults, the state, even on appeal, says that those assaults, prior assaults, were necessary and essential to proving reckless intent on the homicide. That simply isn't the case. If you look at the state's evidence on the homicide charge, it's the evidence demonstrated, and the state argued that it demonstrated, that Mr. Montgomery acted recklessly by repeatedly punching HM until she was unconscious. You don't need additional evidence of prior assaults for which there is no allegation was connected to cause of death to prove that reckless mental state.
Doesn't it show the extreme indifference?
I think the charge itself shows extreme indifference. The evidence on the charged act, if you believe Kayla's testimony, that in and of itself is more than sufficient to establish recklessness. And I will also point out that this was.
All right, we have to interrupt. So I can see where this is going, and it's got my blood pressure in my ears. I feel bad for Rachel because she's on her way to get her hair done. They're going to have hands full. This is all going to be about Kayla not believable. Kayla not believable. Kayla not believable.
I told you he was going to blame her.
Yep.
Told you. I can see these sons move. I can see them for what they are. Yeah.
How are they going to explain all the forensic evidence then?
And they're going to try and cut out these prior acts like it makes a difference. He beat the child to death. Oh, but according to him, Kayla did it. Right. Screw you, you piece of shit. I hate him.
And Kayla is no prom queen, okay?
Yeah.
But
no, I have issues with her too.
She's not.
She protected her kids.
It's not a mental defense on the homicide charge. This was the defense that Mr. Montgomery was not the one who caused the death. It was Kayla Montgomery. And so intent on the homicide charge was not a matter in serious dispute. And I would also like to point out is if you're talking about other act evidence being relevant for intent, that's a 404B evidence that's subject to a 404B analysis. That's not an explanation for it being intrinsic to the charge.
Wasn't as the trial court noted, wasn't the jury entitled to some context about events leading up to December 7th?
I don't know why. I mean, context has to be tied to the actual the charged act. I don't know, and I guess this is a question for the state, but what about their evidence and proof on the homicide it has a hole or a gap in it that is impossible for a jury to understand and reasonably assess without having these prior assaults.
To Justice Donovan's point, your yellow light is on,
Yes.
and if you want to get to harmless error.
I do want to get to harmless error. I think that, as I mentioned before, the homicide-related charges rested exclusively on Kayla Montgomery's version of what happened on December 7th. She had significant credibility problems. She gave multiple inconsistent statements to the police before she eventually gave a statement that led to the basis of her trial testimony. She only gave that story after she had been arrested, jailed and was facing additional jail time. She had theft and other kinds of convictions on her record that raised substantial questions about her credibility. She, according to the state, lied to the grand jury about what happened. And by the time she got to testify in this case, she was serving a prison sentence on perjury. She had significant credibility problems. The admission of all of this other evidence, either through the joinder of the July assault and the prior act evidence leading up to the assault, the homicide, all of that rested on other evidence. And it gave the jury a reason to, even if they likely had substantial doubt about what Kayla said happened on December 7, they could fill in that doubt by relying on the improper admission of the July assault evidence, as well as the prior evidence leading up to the homicide.
Thank you, Attorney Phelan. You've reserved 2 minutes. Attorney Gagne?
Good morning, Your Honors. May it please the court, Sam Gagne for the state of New Hampshire.
Hold on. Is his name Kanye?
I didn't hear it, to be fair. Can you back it up and we'll see?
Is his name Kanye?
I don't know. Yep.
Good morning, Your Honors. May it please the court, Sam Gagne for the state of New Hampshire. Your Honors, the trial court committed no error when it denied the defendant's motion to sever, when it admitted intrinsic evidence, or when it admitted the body cam video. But even if it were to be assumed that the trial court did commit an error, any such error was harmless beyond a reasonable doubt, given the nature of the errors alleged in this appeal and the overwhelming strength of the state's case, which consisted of eyewitness testimony, numerous witnesses who corroborated that eyewitness testimony, and a mountain of physical evidence, the summit of which held only one conclusion, and the jury reached it.
Do you agree with the defense that the murder conviction rested predominantly on Kayla Montgomery's testimony?
Not necessarily, Your Honor. Certainly her testimony played a large part. She was the eyewitness to what happened on December 7th, 2019. There was no specific evidence to corroborate exactly what happened in that car as far as eyewitness testimony. But to the extent that could not be corroborated and Kayla has credibility issues, so much of what Kayla testified to was corroborated by other testimony and physical evidence that she might not even have been aware of, that it would have become very easy for the jury to later credit her testimony about what happened in that car.
So if we excise the July assault, what evidence corroborates Kayla Montgomery's testimony?
Sure, Your Honor. So beginning with the blood in the ceiling of the Fitz shelter, Kayla testified that the defendant hid Harmony's body in a diaper bag and placed her in the ceiling of the shelter at Families in Transition. When the police went to investigate and cut out that part of the ceiling, it was visibly stained with bodily fluids. The DNA tested positive for Harmony Montgomery's DNA, a profile of which was built using her toothbrush. The defendant's fingerprints and palm prints were all over the vent of that ceiling. The only other fingerprints that were found were of the man who installed the ceiling.
But that only shows corroboration of the post-homicide actions of the defendant.
Sure, Your Honor. My ultimate point here is that all of these pieces of corroborating evidence of Kayla saying he hid her in the ceiling, he put her in the freezer at Portland Pie Company, he used a U-Haul to drive her and dispose of her body, he used lime to break her body down. If all of those things could be corroborated by physical evidence to show that Kayla wasn't lying about those things, it becomes a lot easier to credit her testimony when she says, the look of an evil man in that car is why I didn't do more to stop him from raining blows on her face. That becomes a lot easier to buy once the rest of her testimony is credited, and very, very much of her testimony was. again through physical evidence and then through the testimony of other witnesses, such as Travis Beach, a friend of the defendant's. He testifies that, yeah, I helped procure the U-Haul truck. I couldn't get it myself, but my friend Brendan Harris could. Brendan Harris said the same thing. And then the U-Haul records show that Brendan Harris indeed did procure a U-Haul truck. Massachusetts tolls show that the defendant went over the Tobin Bridge in that U-Haul truck on March 4th, 2020 at 4:45 a.m. and he crossed back over going northbound at 5:25 a.m. The records show that there was about 130 miles put on that U-Haul truck, and by the state's calculation, that would have lined up just about with the trip from the U-Haul back to the Econo Lodge down to about where the defendant allegedly disposed of Harmony's body and back up. So there was significant amounts of corroborating evidence. On top of that, outside of the Econo Lodge, Travis Beach says that he's outside with the defendant smoking a cigarette, and the defendant's pacing back and forth repeatedly saying, I effed up, I effed up, I effed up. And Travis asked him, what are you talking about? And he wouldn't clarify. That's the same night that he disposes of Harmony's body. So the evidence just built upon itself over and over and over again. And that's even before we get to consciousness of guilt evidence of the defendant himself. He tells somebody on a jail call that the efforts to find Harmony's body is just a waste of taxpayer money. One could draw an inference from that, yeah, I dumped that in a place you're not going to find it. Additionally, before he was arrested, but well after the murders, the defendant confides in somebody who calls himself a close friend of his that he hated Harmony to his very core because Harmony reminded him of Crystal. That makes it really easy to start believing that this person took on an evil demeanor and rained punches on this 5-year-old girl's head until she was dead.
One of the predicates for the Superior Court's decision to allow the pre-December 7th abuse and neglect of Harmony in was that the court would give a robust instruction to the jury so that it did not take into account those prior acts in order to establish a propensity. Did the Superior Court give that robust instruction? I looked at the instruction and it did not seem to fit that description. Do you recall?
So what I recall, Your Honor, is in the final instructions to the jury, the court did instruct the jury, as is routine, that each indictment must be considered separately, and it was directly instructed to the jury that a finding on one indictment should not influence a finding on the other.
But there was no instruction on this particular evidence, the intrinsic evidence or the July 2019 assault.
I do not recall that, Your Honor.
I didn't see it.
I do not recall that from the record. Speaking of, just to pick up on that, there was some discussion of the intrinsic evidence causing the July 2019 assaults to bleed into the murder charge, creating that concern of propensity evidence.
Well, how do we reconcile the fact that the trial court limited the intrinsic evidence of abuse and neglect to a very specific time frame of 2 weeks prior to November 29th, and then the time frame between late November and December 7th, yet allowed in, obviously, by not severing the July assault? How do we reconcile that?
So I think they can be reconciled. First, I would note that they are certainly two different issues. One's a joinder issue and one's an intrinsic evidence issue. And I think the trial court took the exact right approach. The trial court was cognizant because the state moved for months of abuse and neglect evidence. Months takes us from November 29th. If months is plural, that's October, September at least. Then it could start getting into August. The trial court, my decision is somewhat here. These are joint charges of abuse into September, August, God forbid, July. These cases might start to bleed together. So if the joinder order is to remain a sustainable exercise of discretion, the court has
The defendant's argument, but none of the evidence with respect to the 2 weeks prior to December 7th is material to the crime charged?
Yes.
Sophia said, I can't see. Is Adam there? No, Adam is not there. They're not hauling his ass from Virginia up to New Hampshire for this. They don't need him anyway. He didn't show up to his first trial. The only one he went to, well, he made it to his interrogation. How, I don't know. Didn't have a choice. And at his gun trial.
Your Honor, first, I note that Attorney Phelan mentioned she did not understand why any of that was important. I think the easiest way to respond to that before getting into more substantive reasons is, as this court says time and time again in intrinsic evidence cases, events don't happen in a vacuum. This murder did not happen in a vacuum. The whole story is not told by simply recounting the events of December 7th, 2019. If that's all that is told, all you get is that in a vacuum. I'm not saying this would have been the defense or it could have. It's lost on me, as Justice Gould pointed out, how that could impact the relatedness factors. Perhaps it speaks somewhat to the interest of justice issues, but it does not speak to the relatedness factors. Secondly, the July 2019 assault evidence, it's a little bit difficult to game this out because it's sort of hypothetical, but if these charges were severed, it's certainly possible, if not likely, that the July 2019 evidence could come into the murder trial under Rule 404B. Depending on what the defense and what the state of the facts were, the theories could have been modus operandi, lack of mistake, habit of the defendant in the way he disciplined the child, Harmony, common planner scheme. There's a number of theories that may have come in under anyway. The trial court may have been cognizant of that and thought that was another reason not to try the case twice. But even getting to the Brown factors themselves, the trial court's order is manifestly reasonable. If you go through the 5 factors, the state conceded and the court found there was no temporal and spatial relationship, so that pebble goes on the defendant's scale. The commonality of the victim and the defendant can't be disputed here. That clearly goes on the state's scale. The similarity in the mode of operation. In July 2019, the defendant gets angry at Harmony and he punches her in the face. On December 7, 2019, he gets angry at Harmony and punches her again in the head. I see my red light is on, Your Honor, and so we would ask the courts to affirm the trial court's orders and rest on our papers. Thank you.
Thank you very much, Attorney Gagne. Attorney Phelan, you have 2 minutes.
Thank you. If time, I will cover 3 points. Regarding the corroborating evidence, Justice Gould, the state answered your question and talked about substantial, in their view, substantial corroborating evidence. As you pointed out, Justice Gould, the corroborating evidence is all about post-homicide conduct. And Mr. Montgomery at trial did not contest the charges and agreed to the charges of falsifying physical evidence as well as the abuse of corpse information. So the fact that there was corroborating evidence about those events doesn't mean that Kayla's version of what happened on December 7 was any more true. She had substantial reasons herself and credibility problems to not be telling the truth about what happened. Regarding intrinsic evidence, the state used a lot of words in answering some of your questions. The evidence was necessary to complete the story, to give context, to tell the whole story. This court has been very clear, whether it's talking about intrinsic evidence or 404B evidence, that those are usually passwords, or the court has to carefully construe whether those words are passwords for getting in propensity evidence for a propensity purpose. Evidence has to come in for context when it's necessary and essential to proving the charged act. The events leading up to December 7 in those prior weeks were not essential and necessary under the test this court has applied for considering whether it's intrinsic evidence.
Why isn't it relevant to whether the defendant snapped on December 7th?
Well, that wasn't the defense at trial. And until and unless the defense opens the door to that kind of evidence under that theory, it's not admissible. And as we know, as the trial played out, the defense was not that this was a lack of intent. The defense was he didn't do it. Thank you.
Thank you very much, counsel. Case is submitted. Court recess.
All rise.
Okay. That's it. Court is in recess. Now they have to go make their decision. What do you think the decision is going to be? Because you could tell that the judges had some questions of like, how do we fix this? How do we fix that you didn't separate the prior abuse to the murder? What I didn't like is when the one judge said, well, this is after the fact homicide. He's in jail for murder. So her in the ceiling at the shelter doesn't prove he did it. Well, I'm pretty pissed off now. How about you guys? Yeah. I hope it's denied, but I'm just not liking their tone. They seem to be hanging on every word by that one lady. But when the other attorney came up that said, no, we had other cooperating eyewitnesses. Well, how do we fix this? Just move along and let him keep getting his ass pumped in jail. That's it. That's it. That's all you got to do. Okay, guys, I'm getting another show ready for this afternoon. I didn't know how long this was going to take. If not, we'll do 2 tomorrow because I need to do some work on this one. And this just got sprung on me, to be quite honest, because I don't pay enough attention. But I hope if I don't see you back here later or in Discord or one of the Facebook groups, you have a fabulous Wednesday. Hold on, Crafty Chris said it needs to be denied. His lawyer was arguing more about Kayla. This case wasn't Kayla's, it was Adam's. I know. But what they're going to say is everything hinged on Kayla. And Kayla was caught many times lying to the police. This is a different ballgame now because it's with the Supreme Court of New Hampshire. And worst case scenario, he gets a new trial. And then they're going to go through everything all over again. And another jury is going to sit there and hear about this heinous act. And then they're going to say, no, seems like he did it. Makes me sick. I just don't even understand. Hold on, Joanne, did you get my email? Yes, girlfriend. And I have a ton of peppers, and so I'm going to make pepper jelly. And I can't wait to do it. I did. Thank you so much for that. I thought you would have to put gelatin or something in it. Well, hey, OG Nanny. For those of you just coming in, this hearing, on one hand, I want to say it's a bunch of nothing. On the other hand, I want to say they might side. They might side with that other attorney. Well, before we go, let's take a minute to remember harmony because that's what we're here for. We're here for harmony.